Again, good morning. For anyone who missed my name, I'm Katherine Sandoval. I'm the managing partner here in our California office of Matthiesen, Wickert Lehrer. And I will be presenting today with my colleague, Zahra Aziz, who is a senior associate in our California office. This presentation is going to be an overview covering California wildfire claims. And I know that there's actually several large wildfires that have recently occurred in our neighboring states, such as Oregon. There was that Jack Fire, which burned over 24,000 acres of land and took close to 5 months to fully contain. And I also know about the most recent fire that occurred in Boulder, Colorado, that's called the Marshall Fire. And although I would love to discuss all of those states today, we are going to focus in on California, which has actually been facing horrible wildfire seasons in recent years. But some of the stuff that we discuss today will be applicable to any wildfire claim you do come upon. So wildfires are a natural part of California's landscape, but they have become larger and more damaging recently. A recent study by the University of Washington and UC Santa Barbara looked at the long-term future of wildfires and reveals that a buildup of fuels in conjunction with a severe drought conditions do suggest that we have to brace ourselves for a decade-long increase in both the number and severity of California wildfires. And with it, this catastrophic increase in casualty insurance claims and payments. And let me tell you how prevalent it is right now. In California, I know some of you are not here. We are actually in Southern California today. The weather this week in February is 90 degrees, and actually probably 91 to 92. And in fact, yesterday, or last night, I should say, Southern California faced what's called the Santa Ana winds, which are gusts of 70 miles per hour. And in fact, I woke up this morning to an article that in Laguna Beach, there's a horrible wildfire that just sparked last night due to the dry conditions, brush, and there has been over 10,000 evacuations that have occurred, and you can kind of see it from my office on the horizon, this wildfire. Now, also, I spoke a little bit about the drought conditions. So as I am a native Californian, the droughts we're facing today are just unimaginable. I actually was just up in Big Bear, and there's this beautiful lake called Big Bear Lake up there. And I remember as a child jet skiing on this lake and seeing these beautiful lakefront properties. Well, I just was up there this past weekend, and it was honestly shocking to see that the lake had dried up tremendously. And now those once beautiful lakefront homes are no longer lakefront. They're a dock with no water underneath it and just dry brush. So things have really gotten so bad in California that 1 in every 8 acres of California land has been burned by wildfires in the past decade, just the past 10 years. The majority of wildfires in California are started by human activity. Nearly, I would say about 85% of the fires are usually a result of sparks, campfires, downed power lines, sometimes arson, and also trees that come into contact with power lines that then snap those power lines that cause the spark that then causes the wildfire. And the fires have gotten worse, ironically, because fire suppression has actually gotten better. So wildfires consume undergrowth, dead branches, and other fuel. So each time that we successfully fight this fire, a lot of the fuel that would have burned didn't burn. And let me just go through some statistics so you can really understand how bad the wildfires are here in California. In 2018, there were 7,948 wildfires, with 1,975,086 acres burned. Then in 2019, there were 7,860 wildfires, still a lot of wildfires, but just with 259,823 acres burned. One may ask, well, why? That's a lot less. 2019, we miraculously had a wonderful rainy season, which actually took us out of our severe drought conditions. But let's take us to 2020, and this is just statistics from August all the way up to 2020 of August 30th of 2020. There were 9,917 wildfires, in which an estimated 4,257,863 acres burned throughout California. And that included, unfortunately, 33 fatalities, 10,488 structures that were damaged or destroyed. Now, this chart that you're looking at is some of the most deadly and destructive fires that California has faced. You can see that most of the fires happened in the last 10 years. But let me focus in on that first fire you see up there, the Camp Fire. The Camp Fire happened in 2018 in Butte County up in Northern California. It wasn't just the most destructive fire in the history of California, burning over 150 acres, destroying 18,804 structures, and unfortunately killing 85 people. It also claimed the life of Merced Property and Casualty Company, which had to file for insolvency after facing more than, this is a crazy number, 64 million in claims. And it was just one city alone that completely was leveled. The devastating fire in total has actually resulted in more than 16 billion in insurance claims and counting. So you can imagine why wildfire subrogation, especially in California, is so important. Now I'm going to turn it over to my colleague, Zahra.
Good morning. My name is Zahra Aziz, and I'm a Senior Associate Attorney here at Matthiesen, Wickert Lehrer here in the California office. First of all, thank you, Katherine, for that introduction to California wildfires. Now let's talk about wildfire loss and insurance. So wildfire damage is generally covered by fire insurance or property insurance. The term fire insurance refers to property insurance that covers damages and losses caused by fire. Most policies come with some form of fire protection, but homeowners and business owners may purchase additional coverage in case their property is lost, damaged, or entirely destroyed due to fire. However, most policies do not cover for loss, damage that is caused by theft or expense incurred, whether it's directly or indirectly, by any kind of terrorist activity or intentional act that is not covered by the policy. Most fire policies do not provide coverage for damage due to war, invasion, riots, commotion, or warlike situations. This is important to note in light of the recent municipal riots that occurred in cities like Minneapolis, Portland, and other cities where businesses were burned down and suffered serious damage due to riots. In assessing any wildfire claim, first we have to ask ourselves, who is the insured? The insured can be any person or any entity that the insurer provides fire loss or property damage coverage for under the policy. Insureds can be individual homeowners. It can be individual property owners, anybody who has insurance coverage on the policy. Insureds can be businesses. We have cases where insureds are school districts. Thus, the insureds can be any entity that has a policy covering that property or damage caused by the fire loss. So after you receive a claim related to a wildfire loss, it is really important to dissect the terms of the policy language to make sure that the claim is covered in the policy. Homeowners policy or property policies that cover wildfire damage may cover it in several ways. There are different types of coverages that may be triggered. First of all, dwelling coverage. In insurance terms, the home, office, or property is considered a dwelling, which means its structure, which is protected by that coverage. This coverage helps to pay for the cost to repair the property itself or to pay a lump sum minus the property insurance deductible in the event that the structure or the home is damaged or entirely destroyed in the fire. Another type of coverage that is covered in home or property insurance is called personal property coverage. If the home or property catches fire and things inside are damaged or destroyed by the fire, personal property coverage will help to pay for the cost to replace the items in the home up to the personal property coverage limit. So that's another term that's important to dissect in the policy. The insured can raise their personal property coverage limit and even do what's called scheduling with certain items of personal property that are particularly valuable to give them more comprehensive protection. Another type of coverage is called loss of use coverage. In the event that the home or property is damaged or destroyed by a wildfire and the insured cannot continue to live or work there, loss of use coverage can help to pay for additional living or accommodation expenses. This coverage can also help to cover the cost of relocation, hotels, alternate office space, or short-term rental expenses, food, and even laundry after a wildfire. Another type of coverage is personal liability coverage. A wildfire may damage or destroy the insured's home or property. However, a fire from the insured's property may spread to a neighbor's home or property. Then the insured may be liable for damage to the neighbor's property if their actions or inactions caused or exacerbated the wildfire. In such a situation, the policy must include personal liability coverage in order to provide coverage if the neighbor should assert a claim against the insured for his negligence related to the fire. And last, let's talk about personal umbrella coverage. While a typical homeowner's insurance policy comes with some personal liability coverage, the amount of coverage may not be enough to pay for something as extensive as someone else's home burning down. Here, when investigating the claim, it is important for a claims examiner or anybody examining a wildfire loss to inspect the policy to see if there is personal umbrella insurance to help supplement the coverage limits, including litigation costs. Therefore, we caution that before we're paying out on any wildfire claims, it is important to carefully inspect the policy and make sure that each item of damage submitted by the insured is actually covered by the policy. In the same vein, it's also important to look at the exclusions in the policy language. Generally, the fire insurance only covers accidental fires and not fires intentionally caused by homeowner or property owner. In addition, if a home or business is located in an area prone to wildfires, like Katie was talking about, a lot of areas in Southern California, it may be difficult to get homeowners insurance or property insurance that covers wildfire damage due to the risk involved with insuring homes or properties in these areas. Interestingly, Insurance carriers may refuse to insure a home or property that is in an area that is prone to wildfires. Thus, if you're investigating subrogation potential of a wildfire claim, it is imperative that you review the policy carefully for any exclusions in the policy that may wipe out any possible coverage. Now let's discuss the subrogation rights of the insurer. As we discussed before, the insurer's subrogation rights derive from the language of the policy. Equitable subrogation, on the other hand, derives from the laws of equity and what is fair and reasonable to all parties. Another important step to remember in seeking subrogation for wildfire claims is that the insurer steps in the shoes of the insured. How many times have we heard that? We hear this phrase all the time in the subrogation world. What this means is that the negligence of the insured is imputed on the insurer. So if the insured's negligence played any role in causing the fire or exacerbating the fire loss, the insurer's rights to reimbursement may be reduced or even entirely wiped out. Again, it is important to investigate these issues early in your assessment of the wildfire claim. Now let's look at the costs of wildfire loss to the insurer. This is something that's near and dear to all of us. Here I will speak about the wildfire loss that occurred in Northern California in 2019 called the Kincade Fire. The Kincade Fire occurred in Sonoma County, California. It began in October of 2019. The Kincade Fire burned 77,758 acres until the fire was fully contained in November of 2019. The wildfire threatened over 90,000 structures and caused widespread evacuations throughout Sonoma County. The insurers of the insureds affected by the Kincade Fire had to pay for property damage and all consequential damages caused by the fire, if so provided for in the policy. Again, we have to look at the specific policy language to see what is being claimed by the insured and to see if it is covered by the policy. This goes back to that information that we discussed back in slides number 9 and 10 about policy language, types of coverage contemplated in the policy, and policy exclusions. Therefore, it is really important to carefully dissect policy language as soon as we begin working on a wildfire claim or case. All right, now it's time for our first polling question. The question is, generally, the insurer must pay the insured for the property damage caused by the wildfire and all consequential damages as provided for in the policy. True or false? All right, I see that the majority of the people listening to this webinar answered correctly, which is true. All right. Now we're going to also talk about litigation for reimbursement of wildfire loss damages paid by the insurer. As we all know, the plaintiff or the insurer is authorized to bring a lawsuit or an action as the subrogee for its insureds. The term subrogee means someone who acquires rights in place of another, subrogor, by subrogation, usually by paying the other's debts or expenses in connection with the claim against the third party who caused the damages. Wow, that's a mouthful. So as many of us know, the plaintiff or insurer steps into the shoes of its insured, as noted in the case Allstate versus Mel Rapton. Under the doctrine of subrogation, when an insurer pays any money to its insured for a loss caused by a third party, the insurer succeeds to its insured's rights against the third party in the amount of insurance paid. So as it relates to wildfires, once an insurance company pays its insured for damages caused by the wildfire, the insurance company has the right to pursue recovery against any third party who is responsible for starting the wildfire or exacerbating the conditions that cause the damages due to the wildfire. Well, one of the first things that we need to do when we get a wildfire claim is proceed with our investigation. The first and most important question we need to ask, what was the cause of the wildfire? This is the most critical question to ask because if you're looking for reimbursement, you need to make sure that there is subrogation potential. Therefore, we caution that you do your research early as to the cause of the fire and before you pour a lot of money and time into a case that may not have subrogation potential. So I've listed out 6 steps that we should go through when we get a wildfire claim. First of all, the first step is to identify responsible third parties. This requires the use of a wildfire origin and cause expert who will need to assess the area of the origin of the fire as soon as possible. Delay in starting the investigation can result in loss of evidence, whether it's through firefighting activity, weather, or human interaction. Second, once potential responsible parties are identified, a decision must be made on whether to pursue subrogation and whether subrogation is economically feasible. Investigation and litigation costs for wildfire subrogation typically run in the hundreds of thousands of dollars. As such, if the potential responsible party is not collectible, then the subrogation efforts should be reevaluated. Third, one of the most critical early steps in wildfire subrogation is to preserve evidence. This should start even while the wildfire continues to burn. For example, when electrical utility companies are implicated in the start of that fire, their priority during the initial stages of the fire is the preservation of their equipment and restoring power to their customers. So you need to preserve that evidence early. Fourth, you need to send out notice letters to the potentially responsible parties. Fifth, once all parties are identified, you need to think about a joint inspection of the area. Last, it is really important to understand the laws of the state in which the wildfire occurred. If the potentially responsible party is a governmental entity, then there are likely shortened notice requirements to these defendants. This will be discussed later on in the presentation. So, in order to have a valid claim for subrogation of benefits paid, the wildfire must be the result of negligence, carelessness, or recklessness of the at-fault party. The at-fault party should also have insurance to cover the loss. After all, that's why we are all here. It is important to find the insurer of the at-fault party before spending too much time and money on a wildfire claim. And now I also want to talk about a case where it was determined that there is not a lot of subrogation potential. The tick fire occurred in Santa Clarita, California in October of 2019. Granted, the tick fire burned 4,615 acres of land, destroyed 22 buildings, damaged 27 others, and resulted in the evacuation of 40,000 residents. However, the Los Angeles County Fire Department Arson Investigation Unit confirmed that the person who accidentally started the fire would not be charged with arson, and the matter was not a part of a criminal investigation or a civil complaint. Therefore, it was determined that there was no culpable party to proceed against. So as we've discussed, it is really important to do your research early to see if the wildfire claim that you're working on has subrogation potential. Once you have confirmed that the at-fault party has insurance, start to think about experts. Who can help you understand the cause of the fire? So experts to consult when developing a strategy of your wildfire claim case are cause and origin experts, mechanical engineer expert, electrical engineer experts, especially when you're dealing with utility company defendants and telecommunication company defendants, and environmental engineer experts. This is important when dealing with claims that there was overgrowth or vegetation problems that caused the fire. All right, now we're on to polling question number 2. In order to, and this is another true and false, in order to seek reimbursement for wildfire loss damages, the wildfire must not be the result of negligence, recklessness, or carelessness. True or false? Okay, the majority of us picked false, which is the correct answer. Another part of an investigation of a wildfire claim, and this is in the pre-litigation stage, is to review the safety regulations that govern these potential defendants. The California Public Utilities Commission, shortened CPUC, regulates privately owned and semi-governmental electrical, natural gas, and telecommunications companies. The role of CPUC is to protect consumers and to ensure the provision of safe, reliable utility services and infrastructure. In enacting their regulations, CPUC is given the power to fine utility and other companies that they regulate for failure to comply with their regulations. One of the important regulations that CPUC has is General Order 165. So this provides that electrical utility companies like PG&E and Southern California Edison, shortened SCE, and other telecommunication companies are required to inspect their distribution facilities to maintain safe and reliable systems. Electrical utility companies also have a duty to identify vegetation which poses a foreseeable hazard to power lines or other electrical equipment. This goes back to the dry vegetation and brush that we have here in California. In addition, electrical utility companies have a duty to manage, maintain, and repair their aging infrastructure. Like I said earlier, we all know that the state of California has and continues to experience long periods of drought with extremely hot summer and early fall seasons, which make California especially prone to wildfires. Like Katie, I watched the news last night and I found out that the weatherman is predicting weather up to 90 degrees this weekend in February. This is the middle of winter. So it's we have to be cautious about our weather here in California. So electrical utility companies and telecommunication companies are on notice here in California that their equipment may come into contact with vegetation and that it is probable that a fire will result given these dry conditions here in the state. And as we said, also in other states out here out west. Thus, these potential defendants are deemed to be on notice that such wildfires may result if they do not act with care and properly maintain their equipment. So as we will discuss later in this presentation, it is critical to establish that the defendant was on notice of the dangerous conditions for potential wildfires and include this information in a lawsuit if you're alleging negligence in order to provide that they were on notice, and also negligence per se, so against these utility and telecommunication companies. In proceeding in litigation against electrical utility companies, which is a prominent defendant in these wildfire claims, it is really important to research prior incidents of wildfires involving that potential defendant. For instance, in 1994, PG&E, which is the electrical utility company for Northern California, they were found liable for 739 counts of negligence and fined nearly $30 million by CPUC when their high voltage wires caused a fire in Nevada County, California, after coming into contact with trees. The prosecutors in that matter also uncovered that PG&E had diverted almost $80 million from its tree cutting programs into their profits. An audit by CPUC also showed that PG&E violated electrical grid safety regulations at least 11 times in the North Bay in Northern California in the years prior to the Kincade fire, which we just talked about. They also showed that there was evidence that PG&E knew about a significant risk of wildfires from its ineffective vegetation management programs, unsafe equipment, and aging infrastructure for decades before the Kincade fire. So thus, in dealing with any wildfire litigation, it is really important to do your research early about the history of that utility company and its past involvement in wildfires. This will be really helpful to establish that that utility company was on notice and that they failed to act. In filing lawsuits against these defendants, information about prior lawsuits should be included in your complaint in order to show that the defendant utility company had prior notice leading to these wildfires and they knew about the danger to the public. So another common defendant in these wildfire claims are telecommunication companies. In proceeding in litigation against these companies for causing wildfires, it is also important to research their prior incidents of wildfires. For instance, Southern California Edison and T-Mobile were sued as defendants for the Dorado Fire here in Orange County, California. In that litigation, it was alleged that at the time of the Dorado Fire, both Southern California Edison and T-Mobile were aware of the nature and condition of their equipment and that it would likely cause a wildfire. Under similar facts, Southern California Edison and T-Mobile were both sued as defendants for the Bobcat Fire in Los Angeles County, California. So just like in dealing with wildfire litigation and utility companies, it is important to research the history of potential defendant telecommunication companies and their past involvement in wildfires. So we have discussed throughout my portion of this presentation potential defendants, potential at-fault parties in these wildfire claims, but I want to go over a list of these potential parties with you. The first potential defendants are public utility companies, Pacific Gas and Electric, PG&E, Southern California Edison. It is important to note that PG&E and Southern California Edison are private corporations. However, in California, electric utility companies are also considered quasi-governmental entities because of their ability to take private property by means of eminent domain. In other words, a utility company has the power to force an unwilling property owner to sell their property for a reasonable price for the good of the whole community or in order to build whatever they need in order to service their customers. Later on in the presentation, Katherine will discuss more about eminent domain and the implications that this quasi-governmental status has on suing public utility defendants due to wildfire claims. As we discussed above, phone and telecommunication companies are also potential parties to go after for wildfire claims. Other potential defendants are manufacturers of electrical generators, cities, counties, governmental actors, individuals, homeowners, and property owners. Later on in the presentation, we will discuss in greater detail how to proceed in litigation against these potential defendants. So another thing I wanted to talk about is if the negligence, whether it's action or inaction of a municipality or a government actor, has led to the wildfire and the damages, that municipality or government actor must be listed as a defendant in the complaint. If the potential defendant is a California government actor, one must give written notice within 6 months of the property damage claim or the personal injury claim before filing a lawsuit in a California court. This pre-litigation prerequisite is done in order to give the government agency time to settle the claim. This is all enacted in California Government Code sections 810. It is really important to note, however, that no notice is required to sue PG&E or Southern California Edison as they are private corporations. Although PG&E and Southern California Edison are quasi-governmental actors, no tort claim is required to sue them. If the government actor is a federal government agency, department, or actor, the Federal Tort Claim Act applies, which has a 2-year statute of limitations. Nevertheless, a Federal Tort Claim Act must be served before a lawsuit can be filed. Now to discuss litigation of wildfire claims and the specifics of litigation and potential causes of action, I will turn the presentation over to my colleague, Katherine Sandoval.
Thank you, Zahra. All right, so let's discuss causes of action that arise from these wildfire cases. There are going to be several that you can use against any tortfeasor. That's another word for defendant. But there's going to be certain causes of actions that may be used against only certain tortfeasors. So I'm going to discuss some of the obvious causes of action that you will see. In probably, I would say about 99.9% of wildfire claims, the #1 cause of action that you will see is negligence. So for negligence, you must establish that the tortfeasor owed some sort of duty. So I'm going to take the example of the tortfeasor being a utility company, since we were talking a lot about utility companies previously. So here, some of the duties that a utility company owes is that they had a duty to apply a level of care that's commensurate with and proportionate to the inherent danger in designing, engineering, constructing, operating, and maintaining electrical transmission and distribution systems. Another duty is that duty to maintain appropriate vegetation management programs, and that's for the control of the vegetation surrounding their property. There's also a duty to consider the changing conditions, changing whether it's geographic, the weather, or ecological conditions. So you must establish that the tortfeasor breached that duty by failing to do something. So again, back to our example with the utility company. You can allege that they, one, maybe failed to keep the power lines from sagging. Maybe you've seen that around. Failed to inspect the power lines. Another big one is failed to de-energize exposed power lines during fire-prone conditions. So for example, right now, again, in Southern California, we're facing the Santa Ana winds. Typically, our utility company down here is SoCal Edison. They will de-energize the power lines during this time so that in case one of them snaps or a power line falls, they won't be the cause of it. There won't be any kind of sparks. And also, there's also a failure to follow practices to avoid fire ignition. So finally, you do need to establish that there is a direct and proximate cause of that breach of duty and that the plaintiff was injured. Now, coupled with negligence is negligence per se, and sometimes you will see negligence and negligence per se as one cause of action, and it's all going to be under the umbrella of negligence, but you can also have them as their own. So negligence per se is a doctrine that states that when a person or a corporation violates a particular provision of a statute, that action is presumed to be negligent. Now, it has the same elements as negligence, but for that breach section, you're going to allege what statute was violated. Now, one may ask, what statute did they violate? And that's a very good question. And in a couple of slides, I'm going to go ahead and list several types of statutes that are commonly seen to have been violated. That third cause of action is trespass. And now I just want to let you know, just from a strategic standpoint, I usually will list that cause of action towards the bottom of my causes of action, one of the last ones. And that's only for the fact that I can reference all the facts from the complaint that I've mentioned previously. Because what you'll see is when alleging trespass, you need to step into the shoes of your insured. So let me take this example of property damage. And so what you first would need to allege is that the insured had property, whether it be their own, whether they were tenants, whether they were lawful occupiers. And then that next element is that the tortfeasors allowed that wildfire to start. And then at that point, when I say, okay, let me allege that they allowed the wildfire to start, I usually will say, well, see above in my complaint for the facts as to how this wildfire began. And then the next element is to clearly state that the insured never allowed or granted that permission to have a fire enter their property. Now, I do believe that one may say, well, isn't that kind of obvious? But you have to remember that sometimes wildfires are started on someone's property, i.e. they were maybe making a cookout, maybe there's the example of a gender reveal birthday party on someone's property. So you will need to allege that the trespass was a substantial factor in causing the insured's damages. Now, these next three causes of action will be used dependent on the facts of the particular wildfire case you have. So let's talk about nuisance. Nuisance is alleged by stating that the tortfeasor created a condition or permitted a condition to exist that was harmful to health, it was offensive to the senses, it was an obstruction to the free use of property, so as to interfere with the comfortable enjoyment of life and property. And clearly wildfires are going to be a nuisance to all that they affect. Then there's also premise liability. And most of the time, people will assume that the wildfire started out in the forest. But as I mentioned previously, there can be times where it's actually started on someone's particular property. And property owners have a duty of care to keep their property in a reasonably safe condition. And if they fail to do that, then they can be held liable for any injuries that are sustained. Now, there's this next cause of action that's inverse condemnation. And it's one cause of action that is seen many times in a wildfire suit. And it takes its roots in the Takings Clause of the United States and the California Constitution. And it's the flip side of eminent domain, which Zahra was talking about. And this taking triggers the property owner's right to pursue additional just compensation. So unfortunately, though, for a variety of reasons, the condemning authority may take property or property rights from an owner without declaring a taking and initiating that eminent domain process, thus preventing the property owner from pursuing a claim for just compensation. So in this situation, that property owner would have a right to inverse condemnation claim. And this liability rule does apply to all government agencies as well as utilities. Now, if you recall, I spoke about that negligence per se action, and we asked, well, what would the statutes be that they violated? So the next couple slides, we're going to talk about the specific statutes that can be violated by the tortfeasor. And one of these particular statutes is Public Utilities Code section 2106. And this does allow a public utility company to be held liable for any loss or damage or injury that was caused by them. And the full code is listed on this slide. So this is going to be one where, again, as I said, it's a public utility company like Pacific Gas and Electric or Southern California Edison. And these utility companies are required to comply with the duties of the California Constitution and the order of the Public Utilities Commission. And when they don't comply, which normally happens in a wildfire case, they are liable. So the question is, how and what do we need to allege to say that they violated Public Utilities Code section 2106? Well, as a public utility, they are required to provide and maintain service, equipment, and facilities, and it's in a manner adequate to maintain the safety, health, and convenience of their customers. And that's pursuant to Public Utilities Code section 451. And there's going to be many times that you will find that electrical poles have not been maintained. So they should have either replaced those electrical poles. And the reason why that is a lot of times these electrical poles are made out of a certain type of wood that over the years deteriorate, and they need to come in and replace them. Now, public utility companies are also required to design and engineer and manage and maintain the electrical supply lines. And that's going to be in a manner consistent to the Public Utility Commission General Orders 95 and 165 and Rule 33.1. And this is especially important here in California because although I know many will say we don't have weather, we don't have winter, we unfortunately do have the type of weather that sparks these wildfires. As I mentioned, we have the Santa Ana winds blowing with the dry brush, and we again had a brush fire that ignited last night. So public utility codes are also required to maintain, or public utility companies, I apologize, are required to maintain vegetation, and that's going to be in compliance with the public resources codes and the health and safety codes that are listed on that slide. And this is important because utility companies are responsible for the undergrowth that surrounds their power lines and their property. And again, one may ask, well, why does that even matter? But it really, really does matter here in California with how easily a brush fire can be started if dry brush isn't cleared out properly. Now there's Health and Safety Code section 13007. And this is a cause of action that's against any defendant. So this says that any person who personally or through another willfully, negligently, or in violation of law sets fire to, allows fire to be set, or allows a fire kindled or attended by him to escape to the property of the other, whether it's privately or publicly owned, is going to be liable to the owner of such property. So I'm going to give you an example. In San Bernardino, there was what wound up being called the El Dorado Fire, or also known as the Gender Reveal Fire. And that actually began because this couple decided to use a smoke generation pyrotechnic device, and they set an entire field that was full of dry brush on fire on a windy day, and it immediately spread. So because they allowed that fire to be set, they can be held liable for violation of Safety Code Section 13007. Now we're on polling question number 3. Negligence is a cause of action in a wildfire litigation lawsuit, true or false? All right, it looks like we have about 85% of the vote in, and it is true. Now, litigation, we've gone through those various types of causes of action, and I kind of want to walk through how it comes together. So I have not seen in any recent years where defendants outright are going to admit that, hey, let's settle this wildfire claim. Yes, we were the cause. We know we were the cause. We said we were the cause. They don't settle because I can only speculate. They want to see how many claims are going to come at them, and they also want to see how much exposure they have. So normally a complaint is going to be filed. You're going to list all your causes of action that are appropriate depending on your set of facts. And then you're going to want to file in state court. And I say you want to file in state court. Why? Well, number one is a jury is far more favorable. They're less conservative in state court. And federal court is much, much more fast-paced, and it tends to have really strict rules. Discovery portion of a case is extremely short. So allowing a case to be heard in state court is going to be a lot better in terms of being able to complete all your discovery. There's also being able to move the trial around. And then the other thing I want to mention is that typically what will happen is you'll have tons of subrogation plaintiffs, tons of individual plaintiffs, and usually the subrogation plaintiffs will all get together as a group, and that's because we all have those hard dollar damages, and it's a crapshoot really whether the defendant is going to want to deal with the subrogation plaintiffs first, or if they're going to want to deal with individual plaintiffs. Defendants sometimes I see will want to settle with the subro plaintiffs first just because it gets us out of the way. But sometimes they'll want to settle with the individual plaintiffs first and say, here, subro, this is all that's left over. You guys figure that out. Now, an important thing to note about litigating wildfire cases is that sometimes the defendants are going to want to remove the case to federal court, and there are two bases for going ahead and removing to federal court. It's based on the federal enclave jurisdiction and the federal officer removal jurisdiction. Now, I'm going to quickly dive through them. I will say that just overall, these two bases for removing to federal court have not worked in the past. So just briefly, this slide shows you exactly where the federal enclave jurisdiction comes from. It comes from Article 1, Section 8 of the U.S. Constitution. And what it does is it gave Congress the power to pass laws concerning land that the federal government have purchased for the states. But what does it mean for defendants today is probably the biggest question. It just means that when an injury occurs in a federal enclave, which includes courthouses, military bases, national forests, and parks, the defendant may remove a case filed in the state court to the federal court because the district court would have original jurisdiction. Typically, these are only seen, though, really when it's a manufacturer of asbestos products, or you have a factual scenario where there's a construction accident involving a subcontractor that happens on military bases. It has not worked in wildfire claims as of late. There's also the federal officer removal statute. Again, this is on that slide, and it just covers all cases where a federal officer can raise a colorable federal defense arising out of their duty to enforce the federal law. And what you have to show is that it is a person within the meaning of the statute, that there's a causal nexus between its actions, and it can assert a colorable federal defense. So how this was particularly used in a wildfire claim is that utility companies are going to say that when they're running power lines through a national forest, there are rules and regulations that are set by the U.S. Forest Service. And there's been an argument that the utility companies have to listen to the Forest Service because they have to listen to their vegetation plans. But that really has not worked, because all that the Forest Service normally dictates to a utility company is that they just have to have a plan, but they don't actually enforce the plan. Obviously, the plan is enforced by the utility companies themselves. Now, one thing that you guys must be thinking, and I know we're almost out of time, is that you may have seen that there's going to be tons and tons of parties involved. So as I mentioned before, subrogation plaintiffs do work together. Normally, courts will require some sort of management or organization program. And then all parties are going to have to get together, which it takes a lot of coordination, but developing a discovery plan. And one of the very first things that any kind of wildfire claim litigation likes to determine is how many layers of insurance are there. Because we want to know, A, what carriers are involved and what is the settlement potential pot that we're looking at. So I will say that wildfire litigation is very, very drawn out, and it is long, and it takes several mediations, but you do get the results you want. So just quickly, I do want to talk about statutes of limitations. Again, personal injury wrongful death is 2 years. I'm just mentioning that because if you do wind up having a wrongful death claim, or you do have death benefits that you've paid out, you can subrogate for the death benefit. There's also property damage, which wildfires do a lot of destruction to, and that's 3 years. As Zahra had mentioned previously, there's the Federal Tort Claim Act and the California Tort Claim Act. I quickly would like to mention something about California, though, and COVID. It's called Emergency Rule 9. It told the statute of limitations and repose for civil causes of action that exceed that 180 days. And it told it from April 6, 2020 until October 1st, 2020. So that means if the statute was running during that time, it was paused for 178 days, and then you got an additional 178 days. And why do I mention that? Because as you can see, these are a list of a lot of wildfires with active litigation going on right now. And you still may have time to get involved in these litigation claims. So I would recommend that you go ahead and read, just kind of look at these wildfires. I want to mention there's also the bonfire that happened in Silverado Canyon here in Orange County. And there's a Saddle Ridge fire that both also have active litigation going on. So if you want to go back and maybe you accidentally close those fire loss wildfire claims, just take a look and see if it's one of these fires. As well as I do want to just keep this in the forefront of your head is that if the Colorado fire that occurred in Boulder, it is still under investigation, but they are looking at a mine that may have caused that fire. So just be on a lookout for all of these claims. Now, we do have a couple subrogation books that are available. Covers work comp, ERISA, automobile, where's the beef, fundamentals of insurance coverage. It's a wonderful resource, and it's available through our Juris Publication website shown on the screen, as well as at our website. Unfortunately, we've run out of time for questions. We completely appreciate all questions that you may have, and we will respond to them as quickly as we can. Thank you so much for attending. We really do appreciate it. Have a wonderful rest of your week.